Hello, good afternoon everybody and welcome to this Wednesday webinar. Burkitt Long is offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. My name is Claudia Hubert and I'm a solicitor in the Divorce and Family team at Burkitt Long, and later I'll be handing over to my colleagues Helena Oxley, a solicitor in the BLHR and Employment team, and then to Katie Stevenson, a solicitor in the Wills Trust and Probate team. This week, we're going to be giving you a guide to the law for individuals in the trans community. We will take questions at the end, so please do make use of the Q&A facility. My details will also be provided at the end of the presentation, and the family team at Burkitt Long do offer a free 15-minute telephone consultation to see how we can help you further. So if you do have any questions that you don't feel like you want to raise on the Q&A, please just drop me an email or give me a call. Next slide, please. So for today's webinar, I will begin by talking about gender recognition certificates, what they are, how you get one, and the impact they can have on family life. I will then pass over to Helena, who will deal with trans as a protected characteristic and discrimination in the workplace, and then we'll round off with Katie, who will talk to you about gifts in wills after gender reassignment. We'll then finish with some live questions, and then, yeah, that'll be it. So next slide, please. This is just a note to say that the information provided within this presentation is for general purposes only and does not constitute legal advice. This information is correct as of today's date of the 20th of April 2022, and it is subject to legislative change. Next slide, please. Next slide, please. Yep. So firstly, what is a gender recognition certificate and why might one be needed? So at birth, an individual's gender is registered on their birth certificate. However, it may become apparent later in life that that gender assigned at birth does not match that individual's true gender identity. This means that an individual may be treated as the gender on their birth certificate, regardless of their actual gender identity. And this can have an impact on things like pensions, benefits, and marriage or civil partnership. So to address this, an individual may take steps to transition and live using the gender they identify with, and this is where a gender recognition certificate can be really helpful. So the certificate is a formal document issued by the Gender Recognition Panel to legally recognise an individual's acquired gender in the UK. This means you can change your legal gender from male to female or from female to male. Unfortunately, in the UK, there is not yet any legal recognition of other genders, nor is there the ability to legally have no gender or an unspecified gender. So once a gender recognition certificate is granted by the panel, this could be used as evidence of your new legal gender. And it is at this point that you'll be able to obtain a replacement birth certificate with your preferred and now legal gender on it. You will also, from the date of issue, be considered in the eyes of the law to be of your acquired gender. However, a certificate is not retrospective, so it doesn't rewrite your gender history. All of your legal rights and responsibilities will correspond to your legally updated gender. So, for example, your national insurance contributions that you pay will be based on your acquired gender, and your pensionable age will also then be the same as your acquired gender. If following receipt of your certificate you think that you may be entitled to your state pension now, you should contact the Pension Service as soon as possible. The Department for Work and Pensions will also reassess any existing benefits and pensions paid to you, and they will notify you of any changes that have resulted from getting the certificate. This can include an increase or decrease in the amount of benefits paid to you, or your entitlement to a benefit or pension may actually start or stop. If you do become eligible for a benefit or pension, you will need to make the claim or application in the usual way. It's really important to be aware that obtaining the certificate can also affect a pension payable to not only you, but to your spouse or civil partner, where that pension is based on your earnings or national insurance contributions. So, for example, if you change your legal gender from female to male after you've reached state pension age for a woman, but before you've reached state pension age for a man, any state pension your spouse is already receiving based on your national insurance contributions will stop, along with your own state pension. Your entitlement to state pension will then be reassessed when you reach your new state pension age. So in terms of making an application for the certificate, this is actually completely optional, but if you want your acquired gender to be legally recognised in the UK, you'll need to make an application for the certificate. This application is made to the Gender Recognition Panel, which are a panel made up of medical and legal professionals. There are currently 3 different routes to get a gender recognition certificate. That's the standard route, the alternative route and the overseas route. There are different criteria which need to be met for each of the routes, and which route is chosen is based on an individual's personal circumstances. However, under all of the routes, you will need to be at least 18 years of age. Now, most people will only actually be able to use the standard route, but this does require the most evidence. So where the other routes can be used, that is preferable. Briefly, we'll go through the standard and overseas route, as these are the most common routes chosen, and we simply do not have enough time today to go into detail on all three routes. So starting with the standard route, you will need a diagnosis of gender dysphoria, gender identity disorder, or transsexualism to have a medical report from a gender specialist confirming this diagnosis. You will also need to obtain a medical report from another doctor, and that will usually be your GP, confirming whether you have had any relevant medical treatment. You also must have been living full-time as a male or female for at least 2 years prior to the application, and you will also need to swear an oath that you intend to continue living full-time as a male or female until death. Now, with the overseas route, this is slightly different, as it is only open to those whose gender has actually already legally been changed in an approved country, and you have the documents to prove that this has been done. Next slide, please. So once you've determined which route you're going to take, you will need to complete and sign the right statutory declaration for your circumstances. These can be prepared and witnessed by a solicitor, who will usually charge a nominal fee to do so. Burkitt Long do actually offer free statutory declarations specifically for gender recognition certificates, so please do get in touch with us if you need our help with this. You will then need to fill in the appropriate form based on the route you are choosing and gather the relevant evidence, which will again depend on the route you are taking, but includes things such as the medical evidence from professionals, your birth certificate, and where relevant, your marriage certificate. You will then need to send off the completed application form to the panel, along with the nominal fee of £5 for the application. Your application will then be assessed by the gender recognition panel, and once the panel's made a decision, that will be sent to you with your certificate if you've been successful. If you are granted a full certificate and you have a UK birth entry, the panel will send a full copy of the certificate to the relevant register office as soon as it is issued. You may also be given what is known as an interim certificate, which I'll address in a moment. If your application has been unsuccessful, reasons will be provided by the panel, and you may be able to appeal the decision if you think it is wrong on a point of law. However, your decision letter will go into more detail about that and will inform you how to appeal or to apply for the certificate again. There is actually a lot of scrutiny of the current application process for getting a gender recognition certificate, mainly for being overly medicalised, and there have been calls on the government to remove the requirement of a gender dysphoria diagnosis, and also the requirement to have lived in the acquired gender for 2 years from the process. Another issue that we see with the current system is the cost. Whilst the application fee has been reduced to £5, the costs involved in obtaining the diagnosis of gender dysphoria and having a medical report produced by a specialist can be highly expensive. It remains to be seen what the government will be doing to fix these problems. Next slide, please. So we're now going to discuss the impact that a gender recognition certificate can have on family life. So a big question for a lot of people is what happens if I'm in a marriage or civil partnership when I apply for my certificate. Since 2014, it has been legal for couples who are legally the same sex to get married in England, Scotland and Wales. This means that couples where one or both partners are seeking gender recognition no longer have to end their marriage or civil partnership. However, the impact of gender recognition on marriage and civil partnership is complicated, and it does vary depending on where you live or where you got married or entered into your civil partnership. So if we start with marriage, in England, Wales and Scotland, you can remain married if you apply for a certificate and you and your spouse complete a statutory declaration saying that you both agree to stay married. If your application is successful, you can get a new marriage certificate. However, obtaining a new certificate has no effect on your marriage. If you or your spouse does not want to remain married, or if your spouse does not fill in the statutory declaration, you will get what is known as an interim certificate. Now, previously you could have used this certificate as grounds to end the marriage, but now with the introduction of the long-awaited no-fault divorce, this is no longer necessary. If you do receive an interim certificate and your marriage is registered in England or Wales, you will only get a full certificate once you end your marriage. If your marriage was registered in Scotland, you can use that interim certificate to apply to the Sheriff Court for a full certificate, and you don't need to end the marriage first. The rules with Northern Ireland are a little bit different. If your marriage was registered there, you will only get a full certificate once you end your marriage, as unfortunately same-sex marriage has not yet been legalised there. Moving on to civil partnerships, you can also stay in your civil partnership if it was registered in the UK. Again, your partner must fill in a statutory declaration saying that they agree to remain in the civil partnership. You will get an interim certificate if your partner does not fill in that statutory declaration. And again, you will need to end the civil partnership in order to obtain a full certificate. There are obviously a lot of things to consider if you do end your marriage or civil partnership as a result of obtaining a certificate. For example, the amount of income tax, capital gains tax and inheritance tax you pay may be affected. And if you do end your marriage or civil partnership as a result of your certificate, you should contact HMRC to advise them of your change in circumstances. Next slide, please. Another important question is what impact a gender recognition certificate has on you as a parent of a child. So the law says that obtaining gender recognition does not affect your status as a mother or father. This means that you can be a mother even if legally male, and you can be a father even if legally female. Now, that may not reflect how an individual identifies their name and relationship with their child, but no legal status or rights are lost in respect of someone's children as a result of changing legal gender. This also means you cannot have your children's birth certificates altered to include your revised name or gender. Now, unfortunately, there is no clear provision in UK legislation for trans parents who conceive after having transitioned, and the current law can produce some odd outcomes. In a recent case, a trans man, so legally male but with a gender recognition certificate, gave birth to a son in the UK and wanted to be recorded as his son's parent or father on the birth certificate. But the High Court and later the Court of Appeal ruled that he had to be registered as a mother, as the person who gave birth to the child, despite the fact he was a man by law. Now, this has obviously thrown some doubt on how the law works for other trans parents moving forward. There is obviously an argument that the birth registration system is not fit for purpose because it's tethered to traditional understandings of family law and family life and does not adequately account for modern families. However, this does not actually affect how you identify your relationship with your child. And if you are a trans man who is registered on the child's birth certificate as the mother, this obviously doesn't prevent your child from calling you their father. It's completely down to an individual's choice. Lastly, an important thing to note is the fact that as your status as a parent of a child is not affected, this also means your status as a non-resident parent or a parent with care in child maintenance terms is also not affected. However, if due to getting a certificate, a person's benefit entitlement changes, then the amount of child support that they have to pay may also change. So that's definitely worth keeping in mind. So that brings me to the end of my part of the webinar, and I'll now be passing over to my colleague Helena, who will be discussing trans as a protected characteristic and discrimination in the workplace.
Very much, Claudia. So as just explained, I will be discussing trans as a protected characteristic and discrimination in the workplace. Unfortunately, discrimination in the workplace is something that many still experience, and I think it's really important that individuals know their legal rights and how the law protects them in order to apply this in practice when needed. And so in order to do that, I'll be breaking this down into 3 things for us to understand. 1 being what the legal protection is, 2, how it is applied, and 3, examples in practice. Next slide, please. So what is the legal protection? We looked to the Equality Act 2010, which aims to provide protection to individuals in respect of 9 protected characteristics. Protected characteristics are characteristics or attributes of an individual that the law seeks to protect, such as race, sex, and the relevant characteristic for the purposes of this webinar is gender reassignment, which is set out in section 7.1 of the Equality Act 2010. So let's unpick that legal definition. A person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing psychological or other attributes of sex. The Equality Act requires that a person has at least proposed to undergo gender reassignment, but does not require a proposal to be irreversible. So a person who starts the gender reassignment process, but then decides to stop, still has the protected characteristic of gender reassignment. So in practice, a woman making the transition to be a man and a man making the transition to be a woman both share the characteristic of gender reassignment. So if an individual's gender identity does not match the gender they were assigned at birth, and that individual begins the process of aligning their life and physical identity to match their gender identity, which is referred to as transitioning, then that legal protection will be applicable to them. Next slide, please. So how does the law protect trans individuals that meet the legal definition in the workplace? So the protection extends to employees, workers, partners, office holders, and in some circumstances will also extend to self-employed contractors. And gender reassignment discrimination is prohibited during all stages of the employment relationship. So that will include recruitment, terms and conditions, promotions, transfers, dismissals, and training. And the law recognises discrimination in 4 categories, which are direct, indirect, harassment and victimisation, and we will consider each in turn now. Starting with direct discrimination, which is found in section 13 of the Equality Act. So legislation often details person A and person B. Person A is often the employer or the individual being complained about, and person B is often the employee or the complainant, and I will be referring to person A and person B in discussing the definitions with you now. So direct discrimination. Person A discriminates against person B if, because of gender reassignment, person A treats person B less favourably than person A treats or would treat others. So an example of direct gender reassignment discrimination here is where a saleswoman informs her employer that she intends to spend the rest of her life living as a man. As a result, the individual is demoted to a role without client contact. The employer increases the individual's salary to make up for the loss of job status. However, the increase in pay still constitutes a demotion and therefore less favourable treatment because of gender reassignment. Moving on to have a look at indirect discrimination, which is found in section 19 of the Equality Act. Indirect gender reassignment discrimination refers to a PCP, which is known as a provision, criterion or practice. So a PCP is a wide concept which includes such things as selection criteria, contractual and non-contractual policies, employment rules, or any other formal or informal practices that appear to be neutral, so applying to everyone regardless of any characteristics, but have the effect of disadvantaging trans employees or job applicants. So in the law, this definition is person A discriminates against person B if person A applies to person B a provision, criterion or practice which is discriminatory in relation to a relevant protected characteristic of person B. And person A cannot justify the PCP by showing it to be a proportionate means of achieving a legitimate aim. So an example of this would be where an employer starts an induction session for new staff with an icebreaker designed to introduce everybody in the room. Each worker is required to provide a picture of themselves as a toddler. One worker is a transgender woman who does not wish her colleagues to know that she was brought up as a boy. When she does not bring a photo in, the employer criticises her in front of the group for not joining in. It would be no defence that it did not occur to the employer that this worker may feel disadvantaged by the requirement to disclose such information, and this would in fact be indirect gender reassignment discrimination. Next, we'll have a look at harassment, which is detailed in section 26 of the Equality Act. Gender reassignment harassment occurs where person A engages in unwanted conduct related to gender reassignment, and that conduct has the purpose or effect of violating person B's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for person B. In deciding whether conduct has this effect, the following are taken into account. 1, person B's perception of the conduct. 2, the other circumstances of the case. And 3, whether it is reasonable for the conduct to have that effect. On the final slide, I will be discussing some gender reassignment harassment case law, which will detail some examples there. So the final type of discrimination which is recognised by the law is victimisation, and this can be found in section 27 of the Equality Act. Victimisation occurs where person A subjects person B to a detriment because person B has done, intends to do, or is suspected of doing or intending to do any of the following protected acts. 1. Bringing proceedings under the Equality Act. 2. Giving evidence or information in connection with proceedings under the Equality Act, regardless of who brought those proceedings. And 3. Doing any other thing for the purposes of or in connection with the Equality Act. So some common examples of victimisation are being disciplined after bringing a tribunal claim against their employer, being disciplined after making informal complaints to management of unlawful discrimination or providing information supporting such a complaint, and also where a job applicant or employee is victimised because they have made or intend to make a discrimination complaint. Next slide, please. So my final slide will be looking at some case law, particularly cases that were brought under gender reassignment harassment, so having a think about that in practice. So before we have a look at that, just a reminder of the law. So when dealing with unwanted conduct, there are 3 things that we've discussed that we need to consider. 1 being B's perception of the conduct, 2, the other circumstances of the case, and 3, whether it is reasonable for that conduct to have the effect. The first case we'll have a look at was successful for the claimant, and this is the case of Lawrence and Wills. Just to give you the background of the case there, the claimant was undergoing a process of gender reassignment from male to female. She worked as a receptionist in a massage sauna that operated as a meeting place for gay and bisexual men. Her employer required her to attend work presenting as a man and required her to be addressed as Mark rather than Abigail, feeling that male customers in a state of undress might object to the presence of a woman. She brought a claim for gender reassignment harassment in the Employment Tribunal, and the Employment Tribunal held that requiring the claimant to be called Mark was unwanted conduct that had the effect of creating an intimidating, hostile, degrading, humiliating or offensive environment for her. And the claimant clearly wished to be known as Abigail, and this was an important part of her real life experience. In contrast is the case of Chapman and the Chief Constable of Essex Police, where the claimant was unsuccessful. So the background of this case concerned a police officer with long-standing service who was a transgender woman. She complained that on 3 occasions, control room staff challenged her identity when she called in, and she felt forced to explain that she was transgender. She brought claims of harassment in the Employment Tribunal. The operators did not know that she was transgender, and she did accept that she had a deep voice. An Employment Tribunal rejected her claims of harassment, deciding that she was oversensitive and unreasonably offended when questioned, and it was not reasonable for her to feel harassed by this conduct, and any female officer with a deep voice would have been treated the same. So in contrast to the first case, in this second case, the individual was not able to overcome that 3rd hurdle that we've discussed, which is whether it was reasonable for the conduct to have that effect. So that was a whistle-stop tour of the law and how it's applied in practice. I'll be very happy to answer any questions at the end of the webinar, either live, or if there's anything you'd like to send me separately, then I'd be happy to hear from anybody. And I shall now pass you over to my colleague, Katie.
Thanks, Helena. Right, so I'm going to be discussing today gifts in wills after gender reassignment. I'm also looking at some legislation that's come in over the last few years. Yeah, so we can jump right in and go on to the next slide, please. So first of all, we're looking at the Civil Partnership Act 2004. Now, this came into effect on the 5th of December 2005. And in relation to succession planning on death, the provisions were designed to put same-sex couples in the same position as married couples. And obviously from the 2nd of December 2019, opposite-sex couples can also enter into civil partnerships as well. So the main changes that were brought about by the Civil Partnership Act in 2004 were that, so if you had a will in existence already and then you then formed a civil partnership, that will would be revoked, and that's still a common thing that we come across today. Not many people know about that their will was revoked if they enter into a marriage or civil partnership. The only real exception is if you're making a will in expectation of that civil partnership. So that was something that was brought in then. A gift in a will to a formal civil partner or former spouse, that is treated as lapsing. So say if you'd made a will in your lifetime, leaving your entire estate to your civil partner or spouse, then basically if you were to then get divorced or the civil partnership was to dissolve, then that gift would fail. So it would be treated as if they had predeceased you. Gifts attested by a civil partner are void. So basically, if you've got a will where you have left your estate to your child, but then their own civil partner acts as a witness to your will, then their gift in that will fails. So it's really important that obviously with your witnesses, they are independent at all times. And obviously just speak to us if you have any questions. It also meant that civil partners could benefit from an intestacy. So if someone dies without a will, then they die intestate. And then, yeah, it will obviously be up to the rules of intestacy, which I will go into a little bit later about who benefits from your estate, but a civil partner can benefit. And this also includes having rights to take the home, the family home, in or towards satisfaction of their entitlement. So that was an important point. It also allowed, the Civil Partnership Act, it allowed civil partners to have the same rights as spouses in making applications under the Inheritance Provision for Family Independence Act. So if you haven't been provided for under a will when you should have, then you can make an application for reasonable financial provision under that act. So that is, again, important to know. So if we could move on to the next slide, please. So we then have the Marriage Same-Sex Couples Act 2013. Now this came into force on the 13th of March 2014, and it made same-sex marriages lawful. So the conversion of a civil partnership into a marriage does not actually revoke a will, which is good news, and does not affect any disposition in existing will either. So generally, references in an instrument, so a written document, in kind of referencing marriage will be treated as including a reference to a same-sex marriage. However, we do need to be really careful because a will or a trust made before the 13th of March 2014 won't apply in this instance. So again, so if I kind of reiterate where that's going to come from, so most likely to be common if you have a discretionary trust will in place that lists a class of beneficiaries, with one being my children, spouses or civil partners. If that will was made before the 13th of March 2014, then that's the spouse reference will only refer to an opposite sex marriage and not a same-sex marriage. Any references to spouse for wills created after the 13th of March 2014 will be recognised as including same-sex marriages as well. So that is an important point. Review your will if it was made before the 13th of March 2014 and that sort of situation applies. It's also important just to consider any trusts. So if you've done any lifetime planning and you've made a trust in your lifetime, then if the trusts were made before the 13th of March 2014 and the settlor, so the settlor is the person who creates the trust, the settlor marries their same-sex partner, then this could result in a trust becoming settlor interested, which can have a number of inheritance tax consequences and various tax consequences actually. So again, we're definitely worth considering reviewing if that is in your position. Next slide, please. So, sorry about that. We're moving on to the Gender Recognition Act. So the Gender Recognition Act came into force on the 4th of April 2005. And this provides transgender individuals who have obtained a full gender recognition certificate with legal recognition in their acquired gender. So the effect is, for example, that a male to female transgender individual will be legally recognised as a woman in English law for all purposes. However, the grant of a full gender recognition certificate does not affect the distribution of property under a will or other instrument made before the 4th of April 2005. So to kind of reiterate that point, I've used an example of Diane. So Diane has 2 sons, John and Ben, and 2 daughters, Laura and Millie. and she makes a will leaving her estate to say 50% of my estate to my sons and 50% to my daughters. After making the will, one of the sons, John, transitions from being a male to female and changes their name to Jane and obtains a gender recognition certificate. If Diane had made her will before the 4th of April 2005, then for succession purposes, Jane would be recognised by what is on her birth certificate, so she would be treated as a son, and therefore the estate would be divided as 50% between Jane and Ben and 50% between Laura and Millie. However, if Diane's will was made after the 4th of April 2005, then for succession purposes, Jane would be recognised by her acquired gender, and so the estate would be divided as 50% to Ben and 50% split equally between Jane, Laura and Millie. So obviously that wasn't the testator's intention at all. So to get around this, we want to make sure that your will is drafted in gender neutral terms. So I tend to use things like my children in that instance, or I just name them. So a gift to a person by name is a gift to that person, even if they change their name. So if John was named under the will, but subsequently changed their name to Jane by the date of death of testator, the gift would still take effect as Jane can prove that she was previously John. Obviously, there is always a way to kind of appeal this, and if Diane died having made her will after the 4th of April 2005, which would have resulted in Jane receiving less of the estate, Jane could apply to the courts on the grounds of being adversely affected. Another option would be that Jane could enter into a deed of variation with her siblings to redistribute the estate as Diane had originally intended, but obviously you're then at the mercy of the other siblings to give you their share. So it's not something that I would recommend. So if we can move on to the next slide, please. So Claudia's already mentioned this point already, but just in relation to marriage and civil partnership. So you can stay married and in your civil partnership when you're applying for a gender recognition certificate. As she mentioned, there must be a statutory declaration saying that you both agree to stay married or within that civil partnership. And obviously at Birkett Long, we can do that for you. So if we go on to the next slide, please. So the benefits of having a will cannot be stated enough, really. I mean, obviously you get to choose your executors. So these are the people that will administer your estate. So they should be people that you trust to be able to sort everything out for you. So they will collect in your money, they will hold it for your beneficiaries. They will deal with everything on your death. So it's important you have someone that you trust to do that. Your funeral wishes, it's an opportunity for you to state in there what you would like. So a lot of people, burial, cremation or something else. So that could be a woodland burial, or it could be that you want your organs to be donated for medical research, for instance. It's really up to you. It also gives you an opportunity to put in some special wishes regarding location. So would you like to be cremated? Would you like your ashes to be scattered around? My granddad particularly wants his ashes scattered around Ipswich Town Football Club, which really isn't ideal for us. So hopefully that won't happen. But you can put whatever you want in there. So it's just something for you to consider. And obviously, you get to choose who your beneficiaries are and who inherits. So that's the most important point. You want to be able to state clearly in a legally binding document who inherits your estate. So it's really important to do. Obviously, as well, appointment of guardians. If you've got children who are minors, so under the age of 18, it's likely that you and your partner will have parental responsibility. But you want to make sure that if both of you were to pass away, that you've got guardians under your will that are there to protect your children for you. And then obviously, since the pandemic, with everyone getting pets, do we want to make provision for pets in the will? Do you want to give them to someone that you trust? Do you want to attach a legacy to it? It's really flexible. We can do whatever you want. So just let us know. And as part of the whole will drafting process, we tend to look at your estate in terms of inheritance tax. So we look at your available nil rate bands, we see what's available. In terms of tax planning, civil partners treated the same as married couples. So yeah, we just need to have a look, and we tend to just review the situation, look at your taxable estate, can give you some advice if you need it, and that's that. And then if we go on to the next slide, please. And then finally, we're just looking at what would happen if you die without a will, and that is the situation we just don't want to happen. So this you'll see on the Gazette, rules of intestacy. So this is kind of what happens if you die without a will. So it follows a really strict set of rules, which you can see there, and you can probably work through at your own time. But basically asks if you are married or in a civil partnership. If you are, then most of the estate will pass to your spouse. You'll see that there's what's called a statutory legacy of £270,000 passes to the spouse. They will also receive any joint property. So if you hold property in your joint names as joint tenants, it will pass via survivorship. They will get your personal items as well. So it just depends on who gets what, because as you can see, if you're married with children, then your spouse may not get your full estate, which may not be what your intention is at all. So it's worth having a look through and seeing if any of this applies to you. We would always recommend having a will because it's just certain. You don't want to leave it up to the intestacy rules, to be honest. Another thing I should mention on there as well is that children, now, you may have children from different relationships. You may be in a second marriage. Now, children on intestacy, if you die without a will, then children includes the legally adopted children, but it does not include stepchildren or foster children. So they are not entitled under the intestacy rules, which can be really awful if you wanted them to actually benefit from your estate. So again, if this applies to you, then please make sure they're included. Another thing that comes around a lot is cohabitants, and there's always this idea of, I suppose, common law relationships, and people thinking they're protected because of that, but it's really not the case. You don't, again, as you can see, it asks at the top, are you married or in a civil partnership? If you're not, then do you have any children? There is no provision for your cohabitants, so someone you've been with for years that you're not married to or haven't formed a civil partnership with. So it's really important you are able to provide for them if you want them to have anything. Whilst you can go down the route of a claim if they've been living with you for 2 years, it's expensive, and so please make provision for them under your will. It's just the best thing to do. So I think that now brings me really to the end of my part. So before we take some questions, we will be sending a recording, so it's on there, around tomorrow morning to everyone that signed up to today's webinar. We'll also include a link to a very short feedback survey, which is on the screen. We'd really appreciate it if you could complete that so we can make sure our future webinars are helpful to you. This is one of a series of Wednesday webinars, with our next one being Contract Review, Growth and Exit, 3 strategies to consider for your business, on the 4th of May. If you're interested in our future webinars, please visit our website or our Eventbrite page to sign up. We're now happy to take some questions.
Thank you. I'm going to come to Claudia first, if that's okay. The first question being, what if I change my mind about being married during the application process, but I've already completed a statutory declaration?
So if you change your mind at any time after submitting the statutory declaration, you will just need to contact the Gender Recognition Panel, inform them that you've changed your mind about remaining in the marriage, and they can ensure that it's actioned accordingly, provided that the gender certificate hasn't yet been sent out. Then they should be able to change that, and instead an interim certificate will be sent out.
Excellent, thank you. The next question I have for you is, how can I prove I have been living in my acquired gender for 2 years?
So when you send your application to the Gender Recognition Panel, you will need to send some evidence with that. That will come in a variety of forms, but it will need to be dated and include your name. Common examples include your passport, payslips, bank statements. If you're slightly younger, then student loan documents or even exam results if you don't yet have those sort of documents. The panel advises that you send in around 5 or 6 items for a standard track application, and to make it more helpful for them, they should span across the entire time period of the 2 years.
Brilliant, thank you very much. The next question I have is for Helena. First question being, as non-binary identities are not currently recognised by the law, do non-binary people have any rights or protection under the Equality Act?
Sarah, and thank you for the question. Even though the phrase non-binary is not included as a protected characteristic, I'm pleased to say that there was a case, which is Taylor and Land Rover, in 2020, which involved an individual coming out to the business as non-binary, and that individual started to come into work. This was a male started coming into work dressed as a woman, and during that transition period, unfortunately, did face a lot of discrimination at work, which were unwanted comments, issues with using toilet facilities and that kind of thing. The individual did raise grievances, internal complaints that weren't dealt with, so resigned and brought claims of discrimination under the Equality Act, under the protected characteristic of gender reassignment. And that individual did win their case. And there was an important line that the tribunal said, which I'll read for you, which is that the tribunal held that it was clear that gender reassignment is a spectrum, and that it was beyond any doubt that the claimant fell within the definition of Section 7, which really is this whole proposing to undergoing or have undergone a transition of sex. So I'm pleased to report that yes, it is possible for a non-binary individual to be protected by the Equality Act.
Thank you, Helena. Another question is, if I raise a grievance with my employer about the concerns around the way I'm being treated as a trans woman at work, and then the treatment gets worse after I've made a complaint, would I be protected under the law?
Thank you, Sarah. So yes, there is protection for that. That's an example of victimisation, which I was discussing earlier, as that individual was facing a detriment for carrying out a protected act, and that protected act being raising a grievance that's related to the protected characteristic.
Lovely, thank you. All the other questions I have are to be replied directly, so that's all the questions we have for today.
Oh, sorry about that. So yeah, so just to round up, really, thank you so much for joining us today. Yeah, of course, if you've got any questions at all, then just feel free to contact us directly. And thank you so much for your time.